Let's talk about now the Data Act, which is, as I said, probably the most difficult legislation I had to go through since I started practicing law. What is the purpose of the Data Act? To be honest, it is extremely simple in a sense. The purpose of the Data Act is to make data available. That's very easy to understand. It's very much like what I said about the rest of the other EU Digital Package Acts. It's how you make data circulating from one organization to another. Very much like the DGA, the Data Governance Act, there are different chapters. The problem with those chapters is that they have different scope of application. So somehow the Data Act, very much like the Data Governance Act, it's multiple laws within one law. This is where it's extremely difficult to understand because we're talking about completely different scope of application while we are in the same act. Let's provide you with GDPR. The scope of application of GDPR is material or territorial. Material, you process personal data, you fall within the scope of GDPR. You're based in the Union, you're falling within the scope of GDPR. You're targeting EU resident falling within the scope of the GDPR, and then you just apply GDPR. Here, it's different. Chapter 2, it applies to data sharing in the context of IoT. Chapter 3, it's business-to-business data sharing. So it's slightly different from business to consumer. It's slightly different from business to government. Business to government, that would be Chapter 5. And Chapter 6, it's easy switching between data processing services. So from Chapter 2, where we're talking about connected product, connected service data, then we are moving to Chapter 6 with cloud/edge computing services. So you see, within the same act, we are talking about completely different situations. Let's just provide you with the kind of drawing I like a lot, just to make, or try to make it intelligible, the data flows. We have a concept of data, but unlike GDPR, is not the concept is very inclusive, but the definition is not that determining. Within that concept of data, we have a very strong connected products, such connected services data that goes to data holder. Who is a data holder? That could change from one chapter to another, that could change from one business model to another. Then that data holder may have to share data with users, and users can share their data with third parties. That would be Chapter 2. That would be direct and then indirect access, but there is an additional and an alternative data flow under Chapter 2. If there are specific laws, data recipients, such as within the automotive industry, they can access data. And then same for Chapter 3. I receive that data, but I can share it with someone else. Then we have a completely different data flow with data, not only connected product data, but any type of data that can go to public sector body. That is the result of the pandemic as well. What happened during the pandemic? We had governments and any other public authorities that, I need data to make decisions. Okay, the problem that they did not have any framework for accessing that data. You may have criminal procedures. Okay, I want to access that data because there is a pending criminal case that is very regulated, but it's very limited. I want to access telecommunication data because I want to know where people go during the pandemic. that was also regulated. But somewhere in between, there was nothing. So it was extremely difficult for European governmental bodies or public authorities to access that data. So this is why we had to regulate this information, what we call B2G. And let's go to the last part on the providers of data processing activity. It's all about the concept of portability. And who are we talking about? Big cloud and edge providers. It is a data-centric law, but with very strong competition and antitrust mechanism. What we want here is that I go to Amazon, but you're not locked with Amazon. You can move to Microsoft Azure. You can move to local cloud or edge operators, because that's my data and I can do whatever I want with my data. I can migrate my data from there to there. It's very much like what you do on your computer when you have a folder and you want to switch your data from that folder to another. What you do is just you go there within that folder, take the information and put it somewhere else. That is the purpose of the Data Act. It's all about the circulation and, again, the data flows. Sorry, I got to, that was that one. That was like data flows. So let's focus on the business to government data sharing. So as I said, the purpose here was to enable B2G, so business to government. So it is to allow and structure government or any other public sector body to access data from any data holder. That could be companies, that could be association, that could be would say more limited structures with the individual level. But that can only be made because of exceptional needs. And this is where that was key to get that data from. There is an obligation to determine what is an exceptional need. There are two types of exceptional needs, either for public emergency situation. COVID-19 is very easy to identify there. What is the prerequisite? Inability to obtain data by alternative means in a timely and effective manner and under equivalent conditions. And what type of data they can access? Non-personal data or personal data if necessary, but preferably pseudonymized. So here, government, the purpose of that is to not to have a police state or to have authoritarian regime. We are talking about democracies, and there is no, you can get data to understand better what is at stake at a statistical level, but you do not need, and this is a very strong minimization obligation on GDPR, you do not need to access data as an individual, or I would say identifiable individual level. But government or public authorities may have exceptional needs, but are not subject to emergency situation. Then the prerequisites are slightly different. Absence of data prevent the fulfillment of a specific public interest mission explicitly provided for by law, or exhaustion of all other means of obtaining this data. Meaning, in other words, public bodies can access data if they have no other option. And this is where, so what type of data they can access? Non-personal data, unless anonymization is impossible or highly duly demonstrated necessity to access personal data, but in both cases, after pseudonymization. So again, here, there is always a need for protection of privacy aspects. Let's go shortly and focus on switching between cloud/edge providers. On that, so we're talking about chapter 6. So just to provide you with how easy that data hack is. The data hack provides a definition of what is a data processing service. It is a very simple definition of a digital service that is provided to a customer and that enables ubiquitous and on-demand network access to a shared pool of configurable, scalable, elastic computing resources of centralized, distributed, or highly distributed nature that can be rapidly blah, 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 blah. Very difficult to understand. Basically, we're talking about cloud and edge services. 3 different types of services: IaaS, infrastructure as a service; PaaS, platform as a service; and SaaS, software as a service. And here we're going back to, again, as I said, the antitrust competition philosophy of the EU digital package. IaaS and PaaS are dominantly, they are dominant actors on those markets. Amazon, Microsoft, Google Cloud, they are extremely strong there. And this is where the Data Act, the purpose of the Data Act is a strong focus on that. But it does not apply only to those type of services. It also applies to SaaS, so software as a service. Because, again, any digital law in Europe, the purpose of those laws is to be inclusive. So somehow there should not be any way to circumvent it. Meaning that, let's say that I'm not dealing with the infrastructure and I only provide a service and there you can store your data somewhere else. Okay, it does not mean that you're falling outside the scope of the Data Act. You must provide the same rights to individuals. So first of all, we have an extremely, I would say, complex scope of application. The thing is, who is the provider? Under the Data Act, we don't know, because basically there is no definition of a provider. You have to find out in another act, basically the non-personal regulation, who is the provider. So then you have to understand, what is the life cycle of data? Let's say that I have a connected car. That connected car, for using that car, I have an app. It's on my mobile phone, but ultimately, any data that it goes through my connected car is likely to be stored somewhere else. So as a consumer, can I ask that Nissan, Mercedes, Renault, any car manufacturer say, I don't want that my data is stored at Google Cloud. I want that data be stored somewhere else. But who is the provider of what? The car manufacturer is not providing the cloud service itself. The car manufacturer relies on someone else's services. And so who has the right? Is that me as a consumer, or is that the car manufacturer as the client, as the customer of the cloud or edge service provider? So here, the rights are not exactly the same. As a user with indirect relation with the cloud service provider, I do not have any rights because I'm not the customer. The customer is the car manufacturer because they themselves do not provide the service to the users. Basically, what they do is that they provide a functionality, and that functionality is performed by someone else. But as a car manufacturer, I have rights on that under the Data Act, and I can request the switching from your data stored at AWS, and I can move that data from AWS to Google Cloud Platform or to any other cloud service provider. So again, here there's somehow a consent of portability. Although this is not strictly speaking portability, it's just like I have the ability to migrate the data I'm processing, even if it's someone else's data, but because it's my business and there's an additional or ancillary feature to my key business, doesn't matter, but I'm not the provider of the data processing service. I'm just the user of that processing service for providing my own service. This is where here it's not easy to read and to understand what is at stake. So about that, about once I am a customer of the data processing service, sorry, I just want to stop by. So despite the example, the use case with the connected car situation, let's say that I am a customer of Google Cloud Platform because I want to store my financial statement there. Then I'm a customer. Google Cloud Platform is the data processing service provider, and then I have the ability to migrate my data from one cloud and edge provider to another. So it's just about what is your role? Is that you're a customer of the your direct customer of the data processing provider? Then you have rights. Otherwise, you don't. What type of rights? We're talking about portability, so to speak. It's the ability to migrate. So what could I do? I could, as the customer, I ask my provider of data processing service, and I say, okay, please migrate that data to that other. That's possible. And then you can also require to have migration to on-site. Let's say I don't want to work with any cloud service provider. I just want to store my data on my servers in my house, in my warehouse, in my company. That's a possibility as well. So there is a lot of flexibility here on that part. The thing is, when you're requesting to switch to a data processing service offered by one service provider to another, then you are entering into a contract with the other alternative provider of data processing service. But that data provider of access data processing services, it's merely like that provider receives data, is not allowed to analyze your data. Okay, it's okay. I'm the new data processing provider. This is great. I receive data from a new client. I can rely on that data to analyze my system and reuse that data and so on. No, that's not possible because there is GDPR. So basically, the rights here, it's only about migration. So as you can see, anytime we have a possibility for a stakeholder to reuse data without you knowing it, without you allowing it, that's not possible unless that recipient of data is compliant with GDPR or other legislation. There is no way to circumvent the EU digital package, because if there was any way to do it, the purpose of the competition, the antitrust purposes of that EU digital package has no effect. Technically speaking, legally speaking, neither. So this is where there is a complete, it's on the data flows to reuse would be determining regardless of whether we're talking about that law or that law. Let's have a focus, and that is the last section of my presentation on the connected product, connected service side. So very much like the AI Act, let's say that you're a company or an organization based in Japan or in the US, you're shipping products, connected products, or running connected services from Japan, and those products or services are sold in the EU, then you are subject to the EU Data Act, and that is under Chapter 2 and possibly under Chapter 3. What is the Data Act timeline? The Act entered into force in January 2024 and entered into application mostly on the 12th September 2025, meaning Friday last week. And there's an additional obligation starting in 12th September 2026. What type of services or what type of equipment? It is extremely inclusive. Anything that's connected. So that could be a car, that could be machinery, that could be planes, that could be washing machine, that could be watches, that could be medical devices. It is, again, extremely inclusive. Let's say that you can, your product can share data remotely, you need a cable, doesn't matter, that would be connected. So again, it is very, very large, very broad. Which data are covered by the Data Act? It's connected product, connected services data. That could be non-personal data, merely non-personal, but in practice, who owns or use connected device? Individuals. So in most cases, that is also likely to be personal data under GDPR, and if that connected device relies on tracers, that could be metadata under e-privacy law. So here we have basically almost the same issues. You have the EU digital package that applies, and that EU digital package in most cases requires the application of an additional legislation that could be GDPR, that could be e-privacy. So at first sight, you may think that, oh, this is allowed and not regulated, but because there are personal data, it's going to be regulated at some point. Because personal data is extremely inclusive. So let's say about what type of product data we're talking about. Data generated by the use of a connected product that the manufacturer designed to be retrievable via an electronic communication service, physical connection, or on-device access by user, data holder, a third party, including where relevant, the manufacturer. What is the purpose here? So we talked about DMA and DSA. So online platforms operators. Here we are talking about manufacturers. Let's say that I am the manufacturer of a connected watch. As the manufacturer, I want to get data from the use of that watch because it helps me understand what type of bugs there is, how could I improve my product, and so on. But in practice, I have a monopoly on that data collection mechanism, meaning that my competitor is not able to access the data. The Data Act does not allow competitors to access someone else's data. Okay, it is an explicit restriction. However, my connected watch has a battery, and that battery, it matters to know how it works. So the battery manufacturer, who is not a direct competitor to the connected watch manufacturer, might be very interested in how the battery lasts long depending on the use of the watch. And this is where the battery industry is at the heart of the Chapter 2, the Data Act Chapter 2. Because let's say that a manufacturer of that, the battery manufacturer of the battery within that connected watch, that matters to me to access to that data so that I can improve my batteries. But my competitors would be interested in that as well. So this is exactly where the Data Act applies. It is to avoid manufacturers to have a monopoly, we're talking about competition here, on data knowledge. We're talking about raw data. We're not talking about trade secret. We're not talking about IPs. What is at risk, however, is that let's say that I am the competitor of the batteries manufacturer of my connected watch. I can access the history of every connected watch. And with that, I can do some reverse engineering. So there are some trade secret issues here. So this is where, very much like the DGA, there is a framework for protecting confidentiality obligation. The purpose is that you're going to share data, but it's not endless. Any new recipient to that data is subject to a confidentiality obligation to protect every individual. There are some restrictions. Your direct competitors is not allowed to access your data under the Data Act. Same with the gatekeepers. Oh, very much like the DMA. Why is that? Because the big techs already have dominant position. We should not enable them to strengthen their dominant position so they cannot access data from the Data Act. So no connected device data, no connected services. What type of data we're talking about? In printers, just to give you with printer data, on, off, time, date, battery use for portable printers, et cetera, et cetera. What type of connected service data we're talking about? Saving documents, pictures, saving scanned documents, pictures. We're talking about very technical information. That is technical data or what we call pre-processed data. What is extremely difficult with the Data Act is that you may have a non-personal data at some point of the life cycle, but it may change in time. What is let's just me give you an example. I switch on my connected watch or my connected car. That's personal data. Why is that? It's because you know that there is an individual, actually the owners or the users of that equipment, that use that equipment. Then I switch off. Still personal data because you know when it starts, when it stops. But after that, it's non-personal data. But does it matter? Yes, it does. Especially with a battery equipment system. Because you know, you have a car, a connected car, you switch off that car, the thing is the battery still lives. And at some point, it ends. So that would be very important for battery manufacturers to know how the battery lasts long when the equipment is not used. Typically, that would be determining. What type of data we're talking about? It's very history, technical, raw data. But so inferred data or derived data, meaning that statistics, test drive data, it's outside the scope. Content data. So let's say I'm using an app from my connected watch and I'm sending a message to my wife. This is subject to confidentiality of communication. So you're not allowed as a manufacturer to access that data. So you don't know that I send that to my wife. Let's meet at 4 p.m. somewhere. This is outside the scope. And same with virtual assistant data without link with a connected product or device. So I'm at home. I'm requesting or instructing Alexa to switch on my car so that there is aircon into my car. When I get into my car, then it's cold because outside it's very warm, like right now in Japan. Then that is likely to fall within the scope of the Data Act because it has a link with the connected product or the related service. What type of information we are talking about? We are talking about raw data. Raw data is the digitalization of electrical current, meaning you and I, if we're not engineers, we don't understand what it is. It's just a series of numbers. And then we have what we call a pre-processed data, and it's timestamp. So switching on a device, it's likely to give me, at some point, that series of multiple numbers. At the end, it just switch on at 8:42 a.m. That's all. And that is likely to fall within the scope of the Data Act versus derived data, because the analysis of all this information for every product, and that's statistic and outside the scope of the Data Act. Then you have a sort of triage mechanism, because the Data Act Chapter 2 provides access and then sharing, so meaning that you have to regulate all of this. The data holder will have as an obligation to share data with the users. There's an agreement and there are safeguards because there is trade secret. Then there are some restrictions, as I said. So you, as a user, you are legitimate and you are allowed to access your data, but you're not allowed to share that data with my direct competitors, nor with the gatekeepers, for example, or with a non-EU organization. That's illegal. I am done slightly 3 minutes over what I was supposed to.
Maître Perret, many thanks. Really a warm thank you for guiding us through the complexities of the EU digital package with clarity and stamina. It's really a vast package, and yeah, it's no easy feat to make it digestible. I will ask the staff locally to stop the recording now.